ELAN stands for the Employment and Labor Lawyers Association of Nigeria. Now, ELAN was founded in 2015, and it's the premier professional body for lawyers, academics, and practitioners in the field of employment and labor law across Nigeria. ELAN was conceived to bridge the gap between the evolving world of work and legal advocacy, and it has grown into a thriving network of professionals committed to promoting fairness, expertise, and innovation in the employment law space. Since its incorporation, ELAN has provided a vibrant platform for legal minds to engage, contribute, and lead on issues that matter, from workplace rights and industrial harmony to policy reform and regulatory compliance. Our community includes legal experts, HR professionals, in-house counsels, trade union representatives, public sector stakeholders, and civil society actors, all of whom share a common goal: the promotion of decent work and justice in the workplace. And once again, on behalf of ELAN, I welcome you all to today's webinar. Right now, I will take the profile, I'll read the profile of our speaker, but just a few housekeeping notes. Please, if you have any question as the speaker delivers our session, please do not hesitate to put your questions in the chat group. We will take the questions after the speaker concludes our session. Now, our speaker for today is Mary Ekemezie. Now, Mary is the founder and lead consultant at ME Consults, a client-focused legal consultancy offering a range of top-tier corporate and commercial legal advisory, employment law advice, and business support services. She's also the founder of ME Academy, an e-learning platform designed to bridge the gap between theoretical knowledge and practical realities in the practice of corporate commercial law. Secondly, it supports startups and SMEs in building and sustaining a culture of corporate governance, legal, and regulatory compliance. Mary is an outstanding corporate and investment lawyer with significant corporate transactional experience and an excellent understanding of the Nigerian regulatory environment. Her corporate law expertise is in structuring, coordinating, and advising on market-leading transactions in mergers and acquisitions, private equity, corporate finance, as well as corporate restructurings and regulatory compliance. Mary has advised on several transactions, including the listing of the first exchange-traded fund on the Nigeria Stock Exchange, the merger of the Nigerian subsidiaries of the world's largest brewery, the first dual listing by an indigenous oil and gas company on the London Stock Exchange and on the Nigerian Stock Exchange, and also the joint venture arrangement between an indigenous oil and gas company and the world's largest independent commodities trading company. Now, in addition to her corporate law expertise, Mary has distinguished herself in the area of employment law and is recognized as a national leader by Who's Who Legal. Mary is a well-regarded labor and employment law practitioner known for her excellent work on employment-related issues. She routinely advises national and international businesses on the Nigerian law requirements for employment contracts, employment of foreign nationals, termination of employment contracts, redundancies, and restructuring of employee remuneration structures. Some of Mary's notable employment law advisory include advising on labor matters arising from the merger of AB InBev's Nigerian subsidiaries. She's also advised on the restructuring of Andela's operations in Nigeria, which was a very big one. And she has advised on the employment and labor law matters arising from joint venture agreements between UAC Foods and Tiger Brands. Mary also advised on the employment issues arising from the acquisition of a majority equity interest in a brewery by a South African multinational brewing and beverage company. And Mary also advised on the employment and compliance issues arising from conflict of interest transactions by an executive officer of one of the largest food and beverage companies in Africa. Prior to setting up ME Consults, Mary was a managing associate at Udo Udoma and Bello Osege, UUBO, a full-service corporate law firm advising international and local corporate organizations in a wide spectrum of business issues in Nigeria. Now, during her time at UUBO, she was the firm's representative at the Employment Law Alliance, a global network of local labor and employment attorneys, where she served on the leadership of the African region of the ELA. She is the current chairman of the Employment and Industrial Relations Committee of the NBA's section on business law. And she's a member of the Employment Committee of the Nigerian Bar Association, the NBA, and also a member of the Expert Network of the National Assembly Business Environment Roundtable, NASBA. Now, Mary is an alumna of the Nigeria Leadership Institute, of the NIA, I beg your pardon, NIA Leadership Institute, and the School of Politics, Policy, and Governance. Mary sits on the board of the African Christian Professionals Forum, a Pan-African membership organization for Christian professionals, which is focused on promoting and protecting the sanctity of life, family, religious freedoms, and good governance through research, partnerships, and advocacy. Mary also offers pro bono legal advisory services to the Foundation for African Cultural Heritage, a non-profit, non-governmental coalition of civil society organizations and individuals committed to the preservation and promotion of authentic African cultural values. Now, in addition to her passion for good governance and effective leadership, Mary is committed to mentoring and shaping the lives of children, teens, and young people, and also giving back to the community. In this respect, Mary is the facilitator at the clubs run by Women's Board and Education Cooperation Society for Girls, where she teaches them ethics and human dignity curriculum. She was a visiting lecturer at Wavecrest College of Hospitality, Nigeria's first monotechnic, where she taught hospitality and corporate law. This is an abridged profile of our speaker. So, ladies and gentlemen, please welcome our speaker, Mary Ekemezie. You can give her a thumbs up, clock it, or a round of applause with your emojis.
Thank you, Femi. For some seconds, I wasn't sure who you were describing.
Welcome, Mary.
Thank you very much. It's actually a pleasure to be doing this, and I apologize again to everybody who dialed in last week and we had all of the technical difficulties that made it impossible for us to do this last week. So thank you for joining us this week. We hope that you enjoyed today's session. And I will try not to take much of your time. Please let me know that you can see my slide. So I'll be speaking to you on obligations of HR practitioners in Nigeria. That's the short summary. What I have done in preparing the slides is also to make it, on some level, a quick resource you could refer to in the course of your work. So I have tried not, in some instances, to be very text dense. In some other instances, it would be just bullet points. But the idea is that it's something you can refer to in the course of your work. So I will try to cover this, broadly speaking, 12 topics in an hour. I hope I do, fingers crossed. We're going to just look at the framework for employment and labor law, what you should be concerned about when you're doing when you're looking at recruitment and hiring, the content of your contract, employment contract, and other HR documentation. You should have wages, salaries, workplace health, safety, and employee welfare, disciplinary, issues, grievance handling, and due process. We're going to touch on the Tony issues of exits, right? Termination, redundancies, how to manage exit process. Very briefly, very high level, trade unions and CBAs. Look at some of the emerging areas. I mean, some of them are not so emerging, I suppose. Outsourcing gig work, data protection, and HR technology, and emerging trends. And there'll be like a quick, not exact, some sort of compliance toolkit, something to quickly look at to determine, whether you're on track. And the first thing I want all of the HR practitioners in the room to think about, and those who provide employment law advice, their clients, is that HR is now a compliance function. And so they work hand in hand with legal. So it's very important that HR pays a lot of attention to, if you have the in-house counsel, listen to what they're saying, particularly about trends from the Nigerian Industrial Court, the National Industrial Court of Nigeria. Well, on some level, sometimes their decisions are conflicting, but it is what it is. And also, as a HR practitioner, just keep abreast of what's happening and what best practices are, particularly in the area of tax. I have deliberately not spent a lot of time on tax issues because I'm not a tax expert. I probably have just a line or two on tax. I certainly recommend that you speak to your tax compliance experts in terms of what tax compliance means for your employees going forward. So what I've done here is just about outline the key laws, because we're also in Lagos, I've spoken about the Lagos State People's Law. And so what we're going to look at here is consider sort of our ecosystem. So we have a fragmented legal system. There is no one law that has everything. The Labor Act, which we use as a statutory minimum, applies strictly speaking to workers. Workers are persons who perform manual and clerical work. So your office assistants, front desk officers, the bank tellers in the bank, your drivers, actually cooks, for instance, weirdly chefs also, because their work is manual. But it excludes very clearly persons who provide executive, administrative, technical, and professional functions. The law very specifically excludes that. However, and this law has been around since the 70s, so it's quite old and outdated in many ways. It does need an updating. There's been several attempts to overhaul it. All have failed. Just to quickly digress, this is one thing to keep in mind when you're considering those you want to vote for in the next elections. We do need an update of the Labor Act. So think about legislators who are willing and ready to do that. And if you don't have your PVC, please go and get it. The Nigerian Constitution is also very key law, because it's sort of in the legislative list provide guidance on who can legislate on aspects of labor law. It's predominantly an exclusive matter with the powers sitting with the National Assembly. But there are aspects of it that states also regulate. And we've seen Lagos State lead the charge in this respect. They came up with the HIV and AIDS law in the first instance, 2007, if I'm not mistaken, before the federal law came up to catch up with it. And they also have the Lagos State Special People's Law, which was enacted in 2010, I believe, before we had the national version. So also, depending on what part of the country you're listening in from, is to find out what state laws impact the work you're doing. So I'm going to speak primarily to the national laws and to the Lagos State laws. The Employees Compensation Act speaks about the compensation package for employees who are injured in the course of work. One of the biggest takeaways from the Employees Compensation Act, which repealed the Workmen's Compensation Act, was that it moved away from an insurance obligation, which employers had to maintain, to a contributory regime. It's been around for 16 years now. So it's, I'm sure everybody's pretty much quote and unquote comfortable with the obligation. And then we have the Pension Reform Act. That's been around also for a while. Even though it has Pension Reform Act 2014, that's actually wrong. It's not wrong. That's correct because the law was amended. We have the National Minimum Wage Act and the Factories Act, which is also another very old law. So something that needs some intensive lobbying. The law we have was passed sometime in the 80s, so it's quite old. The Nigerian Data Protection Act 2023, which speaks to the emerging trends that employers must, I remember when I just started practice, all we had really was the Constitution, and then tentatively we had the NISTA bring out the first sort of guidelines, and there was a bit of confusion and sort of debate around is it binding. We've come a long way in over a decade from those years. The Trade Unions Act and Trade Disputes Act regulates, industrial relations. The National Health Insurance Authority Act, which repealed and overhauled sort of what we had before in terms of health insurance for employees. The Immigration Act, which regulates employment of foreign nationals in Nigeria. The Industrial Training Fund Act, which is also another contributory sort of obligation for employers. Ostensibly, what it seeks to do is to provide monies for the fund, to provide training. I do think that maybe some amendments need to be made to the framework of that law, because given the ongoing debate around talent and shortfall of talent, it does not seem to me that the money is being paid to this fund is being used in the ways that the legislators envisage that it would go. So there might be need to have a look at the law again and see how, given the times we live in, the law serves employers better and employees, of course. So that's again one more reason for you to make sure you're voting. The HIV and AIDS Act, which seeks to protect employees from discrimination and introduces very specific obligations for employers to comply with. The Nigerian Tax Administration Act. My apologies, I don't know how I missed that spelling error, but there it is. I'm very new. Like I said, I'm not a tax administrator, I'm not a tax expert at all. So I'm going to really skip this, but I did put it in there because it's very important to the work you do as a HR practitioner and the Lagos State Special People's Law. And so in terms of framework, and I've run through all of the laws, the ways to look at it is to remember that the Constitution is the ground norm, is the law from which all other laws derive its validity. And so that's sort of a basis. So some of the constitutional provisions, specifically Section 254C, which grants the National Industrial Court exclusive jurisdiction, the exclusive and concurrent legislative list. And I would also add some aspects of the fundamental human rights, freedom of association, right to fair hearing, right to dignity at the place of work, freedom from discrimination, all come to play in the course of work. Then there is, of course, the laws, which I have reeled through, and I'm not going to go through it again. And then, very importantly, given the elevation of the Constitution of the NIC to the Superior Court of Record, and their constitutional amendments that set out the scope of the NIC's work, with then having to look at case law, what that means, judicial precedents from both the NIC and appellate courts. And like I said, the last 16 years actually have been some sort of roller coaster of some sort. Then The ILO conventions are very important. They've always been important, but now super important because of the provisions of Section 254C, which allows the courts to apply not just ratified conventions, but also, conventions that have not been ratified. Bottom line, Nigeria is primarily a contractual employment arrangement country. So the contract is your first weapon of defense and attack, or whatever you want to call it. Is it written? Is it documented? So both for the HR practitioners, when looking to specifically your contract, your HR policies, the more documents you have, the better for you. Which is why, like I said at the beginning, this role is now really a compliance role more than anything else. And so what I've done here is sort of pay a bit of attention to what your employment contract should look at, also looking at the age-long worker distinction. And so your Section 7 of the Labor Act sort of says, look, 3 months your employee must have a contract. So there's a bit of quote unquote recognition that sometimes the employee has to join very quickly and it takes a bit of time to complete the onboarding requirement. I don't think it's a great idea. I know it has happened, but I don't think it's a good idea. And then it specifies minimum requirements: name of employer and employee, place of work, duties, work hours, holiday pay, and notice periods. But in addition to that, I would say, look, we have to look at what best practices are saying and what you need to pay attention to. We have to look at the probationary period. And the courts have provided some sort of context around what the probationary period seeks to do for employers, which is effectively a test period between which both parties, not just the employer, but employees also check in. This is where I want to be. Do I want to go? And makes the process a bit easier so that terminations, as long as it happens within that, that period, is quote unquote seamless. Now, one thing I have to say that I have seen many times in contracts is that the fact that an employee is a contract staff, it doesn't mean that they're not entitled to statutory protections. So whether an employee is a contract staff, and by contract staff, I mean those employees who are on revolving door contracts, is set up for a period of 6 months or 1 year or 9 months, and then it ends and then they renew it again and they renew it again, which is one cadre. And then the second cadre are contract staff, employees who are seconded from recruitment agencies, both of them. Now, whether they are recruited from HR agencies or they are on that unending, revolver roller coaster that is constantly revolving, which I completely disagree with. I just think there's something wrong with it. And there should be an end to that sort of revolving door, right? Provide some sort of certainty to the employees. They are entitled to all statutory protections. Pension, group life assurance. You have to take them into cognizance. Now, this is a tricky part for those on the revolving door, which is 9 months, and it's just constantly revolving like a roller coaster. You have to take them into cognizance when you're computing your headcount for ITF, NSITF. You have to take that into cognizance. Now, for the contract staff who are seconded to you from the recruitment agencies, they are not your employees. They work for you, you're the end user. And of course, there's the whole conversation around triangular relationships, which is a valid concern, and something that HR practitioners also should pay attention to when they're drafting those contracts. But for strictly speaking, they are not your employees, and you would not include them if you were calculating contributions for NSITF and for ITF. They're not your employees, strictly speaking, because you pay a company the service and they provide you the employees. They sit on the employee contract, this is on the payroll of those service providers. So probationary period, very important. What are the benefits? Outline them. So I'm speaking to HR practitioners. I'm also going to be providing some tricks of trade, right? I would say that because benefits are, apart from the statutory benefits, pension, life insurance, health insurance, and payouts for injuries, either the one you get from the NSITF or the Lagos State Special People's Law, which in all of my years of practice, I haven't seen anybody who's claimed under that law yet. But I'm actually looking forward to seeing what it looks like when it does happen in practice. But the law exists anyways. And what that law says, this is probably a good time to speak about the law. And what that law says is that employees who are injured in the course of work, it has two elements for compensation for injuries arising from the course of work. The first element is where an employee is injured in the course of work. It provides for a payout of 60 months salary, which is 5 years salary. The question there and sort of my position on that first limb of the compensation regime is that because the Employees Compensation Act covers all of those issues by virtue of the doctrine of covering the field. I certainly think that all of them, that particular limb would be struck down by the court if this was to go to court. That's my opinion. Now, the second limb now deals with injuries sustained by persons who are employed by the company, not in the course of work, just by virtue of being employees. So your employee goes on holidays, has an accident, and can no longer work. You have to pay them 48 months salary. So either with a very generous compensation package, 48 months if it's not in the course of work, which clearly isn't within the contemplation of the Employees Compensation Act. So that's something employers have to be mindful of and plan for. What I have recommended and what I will recommend is get insurance. It's a lot of money. For the 8 month salary is a lot of money. For a very junior employee, that's fine. The employee that earns 1 million, 100,000 a month, that's 4.8 million. It's not a problem. Probably for an employee that earns 200,000, that's 9.6, right? But when we begin to speak to employees that earn millions, an employee that earns 1 million a month, that's 48 millions. Those that earn 5 million a month, that's 300 million. And then the higher ups they go, the more expensive the money you have to pay out looks like. And remember, this is not injuries arising from the course of work. This is just their employees. They've suffered a disability. They can no longer work. You can't find them another position. You have to make this payout to them. So truthfully, get insurance for this. That's my own recommendation. Still on best practices for your contracts, confidentiality obligations, very important, and also have trainings on actually what these confidentiality obligations mean and how employees can can comply with it in practice. Restrictive covenants, the jury is out of what the courts are saying, but I mean, if you look at the FCCPA, the Federal Competition and Consumer Protection Act, it provided a statutory sort of upper limit to, the maximum tenure you can have for restrictive covenants, which is 24 months. So it cannot exceed 24 months. So we have some statutory cover on that particular issue. But the Nigerian courts have also been very, interesting about what they consider to be what they consider to be just, reasonable. So you're looking at scope, you're looking at territory. You're also looking at the level of this employee. It makes no sense to include restrictive covenants for a cleaner who doesn't have access to any proprietary information. What are you trying to say? They can't work elsewhere. So this actually comes in handy for professional staff, those who perform professional executive technical functions, but also depending also on where they sit in the management level, from mid-level to senior management. Data privacy, consent, while important, isn't always the best basis for processing. So you want to use legitimate business interests as a cover. Be very clear on suspension. And if you want to have suspension with pay, please put that in the contract. Now, suspension can be indefinite, unending. It can be a way of punishing an employee we don't like. So you have to constantly review that. If you want garden leave provisions, write it down. What can they do? Because one of the things I have seen when I'm negotiating contracts is, particularly very senior employees, pushing back against, I don't want anybody restructuring my position. If they restructure my position, I'm then deemed a good, it's termination for cause by the company, and I want compensation. Valid reason, but then we have one where things are not going on well. You want them to leave, but you want them on the payroll until they serve out your notice period. But you want to either change the work they do or reduce the work they do. You want that language in there that allows you to do that, which is what garden leave does. But also look at how garden leave, particularly for the startups in the room, look at how garden leave provisions, quote and unquote, interact with your good leaver, bad leaver, focus provisions for termination, and what that also means for vesting. Very specific. What are the grounds for termination? This is also a very keenly contested provision. Again, here I'm speaking to for senior hires. Junior hires have no say. They just take the contract, to be honest. Doesn't mean you shouldn't be fair or you shouldn't be clear, but you negotiate this when you're dealing with senior hires. Be very clear as to what you want to see. Increasingly, we're seeing a pushback around sort of just broad clauses, particularly when they're looking at reputation. And we've seen a couple of termination for reputations from some very high-profile cases in Nigeria. So it's to be very clear as to, again, how these interplay with your vesting requirements and how this interplay with good leaver, bad leaver provisions and clawback mechanisms. Now, the importance between sort of who's an employee and who is a contractor is very important, because it then determines what your obligations to them is. If you misclassify employees, you probably have either if you treat an independent contractor as an employee, you're just overpaying. You're paying taxes you shouldn't pay. You're providing statutory benefits and employment benefits you shouldn't provide. Again, if you then sort of, if the classification goes the wrong way, where you're classifying an employee as an independent contractor, you open yourself up to the risk of back taxes and statutory payments that should be made. So it's important that in sort of trying to determine, what is this employee doing? What is this service provider doing? What is this person doing? We work very closely with your legal team on this, but the courts have provided some sort of guidance. So the control test, the economic test, the power of delegation, the landmark Supreme Court cases, Shena Security and Afropac, and the court listed six items, place of work, who provides the work tools, hours of work, the mode of payment and timing of payment, whether they can delegate. In this unreported case, which I really like, and I mean, I provided you can literally find it online. It's actually on the NICN's website. The court sort of spent a bit more time just looking at the different the control test and the economic test, and very, very useful tests in determining if it's an employee or not. And so while I appreciate that you guys are not lawyers, well, some of you are not lawyers. Increasingly, we're having a number of HR practitioners being lawyers. you would find this an interesting read. I have already sort of spoken to this, but just to provide a bit more context. So in the multiple text, which is a mixed text, what the court is looking at is many things. Who owns equipment? Who is there a personal obligation to carry out the work? Can we delegate? What are the hours of work? Where's the place of work? Is it exclusive? Must I be the one to do it? And then is an agreement for wages and exchange. Sometimes the courts don't just apply one text, they look at multiple things. So I think that it's important to just also as an organization have your own sort of benchmark based on this. That makes it easy for HR practitioners to sort of check the box and think, look, do they meet, if you have a 10-man criteria based on this criteria, the court have outlined 10 points, somebody who made 7 points is very likely an employee. And so I would err on the side of caution. So I did say at the beginning, your role is now really a compliance function. You are the first frontline legal defense because you are advising on issues ranging from statutory remittances, has it been done, data protection. And so here again, you're working very closely with the protection officer of the company, termination risks, and a safe workplace. And I'm going to spend some time on safe workplace with emphasis on some of our cultural nuances that practices that sort of get people in trouble, and also and many of them border on sort of sexual harassment, and broadly speaking, harassment. Of course, culture always, interacts everywhere we go to. There's a way people do things, and the culture has a role to play. What I would say is that even though culture has a role to play and culture is very important, it's even more important that you as a firm, as a company, you have your own internal culture as to what is acceptable behavior in our firm. And please ensure that you enforce sort of adherence. You can't really exhaust what is harassment. I mean, there's also individual preferences at play there. And some people are a bit more sensitive than others. But I think that rule of play, look, there is no have clear rules around romantic interests. Is it allowed or is it prohibited? Personally, I'm a bit more on this issue of laid back. I don't know that there's a reason why we cannot have office romance, as it's called. But I will certainly prohibit office romance between direct reports. There's a conflict of interest right there waiting to happen. Actually, between any sort of high, direct reports and also superior and junior persons. That's a risk waiting to happen there. Have clear rules around disclosures. Look, if somebody says do not touch me this way, enforce that. Enforce and be very clear about no retaliation, because that happens a lot as well. Many times, and particularly women do not speak up about sexual harassment in the workplace. What else would I say on this? Emphasize civil language, okay? We can afford not to be rude in the workplace. So just emphasize civil language in the workplace. What else would I add? And have regular trainings on this issue. So first point of call, have a clear policy around what is acceptable behavior and what is not. Of course, it is not an exhaustive list. It could never be, but it should provide sufficient parameters that allow the persons in question to understand what is acceptable behavior in the office and not. Very clear rules around are drugs allowed, and then what happens with persons who are on drugs that ordinarily would qualify as banned substances because of medical
issues. And here I'm looking at persons who are on some sort of morphine, for instance. And there has to be clear rules around that. You probably want to see a doctor's report. You also want to make sure that those drugs are accessible to others in the workplace. Bottom line, ensure fair treatment of employees and apply fairly equal applications of rules. Here on, I know we're talking about safe workplace here, but something came to mind I don't want to forget, so I'm going to mention it here. One of the things that the National Industrial Court has done, one of the principles which I found very interesting and also just fair, was the principle of legitimate expectation, where persons who've left the firm or business have had a compensation package if they leave on certain pre-agreed grounds. Employees who then leave on those pre-agreed grounds, it's happened once, twice, 3 times consistently. There is a legitimate expectation from persons who are coming afterwards that we're going to get this. There are several cases in which the National Industrial Court has distilled this, involving one of them I remember very clearly was involving health workers, I think laboratory scientists, where for a while the federal government had been allowing them to skip a role. So they moved from, I think, 9 to 11. And then it's gone on for years. And then suddenly they're thinking, we want to rework it. And the court said, look, people already got to use when you get to 9, you're going to jump to 11, you're going to change it. It's just also just be mindful of those and that speaks really to fair treatment of employees, or where there's been persons who live under these conditions, and we saw that in the banking industry, and they got a compensation package, and suddenly it's some other people are living under the same circumstances. I think you're not entitled to it. So if you want to retain discretion, you want to pay attention to the language you use, and actually the practice of what you do, so that you can retain that discretion. Another one is also sort of mathematical sort of approximations. And I saw that it was Fidelity Bank, I think, and they were trying to pay somebody who she's been with them for a while. It was really around gratuity payment, and they were trying to say, oh, she's worked a month less or something ridiculous. And I thought, and the court said no, because even in maths, we know that 4.5 is approximated to 5. So just to be mindful of these. If somebody has been with your company for 4 years and 8 months, and it is the company terminating that contract, very likely the courts are going to hold that any benefits that the person would have been entitled to, they spent 5 years, they would be entitled to it, because the approximate 4.8 months, it's just 4 months short of 5 years. The courts would grant that. It's also the case if before somebody who spent 4 and 10 months had gotten the money, or somebody who spent 4 and 11 months had gotten the money. So just be mindful of those sort of things, that it's human nature. We have, unfortunately, preferences. Just remember that in the workplace, some of those preferences are creating entitlements and creating a culture that you would be asked to uphold going forward. I turn now to sort of recruitmental obligations. It's very important that you have non-discrimination recruitment practices. We always joke about this in Ellen. We see a job advert, male only, female only, 21 to 30 years. Some of these things are quite arbitrary. I don't think I've seen anyone about tribes yet, but probably are getting there. So it's understandably, there's a reason why some of this criteria come out. But what you really don't want is to give someone room for. I haven't seen anyone go to court yet on this issue, but we're becoming a bit more litigious than we were before. So I won't be surprised if somebody goes to court to challenge all of this arbitrary requirements pretty soon. So you want to just avoid discriminatory recruitment practices as much as possible in your hiring metrics. And your contracts must also, like I said, I'm talking about contract. I'm not going to spend more time on that. I'm just going to say, have documented contracts and standardized contracts across boards, and review them periodically against changes based on, best practices and what the courts are saying. Now, onboarding documentation. If you would like to be able to ask an employee to leave because they haven't met your onboarding recommendation, you need to make that contract subject to the completion of the onboarding process and at your own discretion. You also want to make sure that you complete your onboarding processes as quickly as possible. Background checks on privacy, compliance, act for the employee's consent, but also in the language around the language indicating they're going to be doing this include business, legitimate business interests. So you do want consent, yes, but you also want legitimate business interests. And indicate how long you're going to be keeping your records, or just tell them you're going to be keeping the records in accordance with your policies. And if you're saying policies, please refer them to where they can find those policies and include that reference in the document. Of course, for immigration, I cannot emphasize this enough. Expatriate quota approved positions for all the positions. As you know, the position is for the company. I do know that the rules are getting more and more stringent around what's applicable in this regard. Ensure that you make the filings and all of that. Further down, I speak about this. I'm just going to keep going forward. I've already spoken about this, so I'm going to move forward. What I was going to say really is, look, from day one, have that contract of employment. If it's not possible from day one, as quickly as possible, have that contract of employment in place, but certainly not later than the 3-month rule that the courts have, the Labour Act has provided. I did say, this. I did speak about sort of background checks and data compliance, and even for educational reasons, right? Just double checking that the educational qualifications you have are correct, or we ask for references, and sometimes references come in, not too great. I did advise on one such reference where it was a problem. So it's important also that you do have very clear rules around this. And if you would be terminating employment because there are issues you find in these background checks that are concerning for you, make sure that you 2 ways to do that. Either make it a ground of termination, which honestly I would rather not. I would just make the employment contract subject to this and indicate that we'll terminate immediately if you fill those checks, depending on the severity of what you find. So for expatriate quota approval, SCR visa, which they need to come in and which allows them to stay in Nigeria, but process that setback as quickly as possible, and then make sure you don't miss your monthly filings with the Nigerian Immigration Service. Your onboarding, what should it include when the employees come in? Of course, the employment contracts for sure, or the offer letter, depending on what you guys use in your place. But the employee handbook. Now, the jury's out on, and we've had a couple of conflicting discussions around employee handbook. Does it have to be explicitly incorporated to the binding? Or I generally tend to incorporate it, and then I provide a hierarchy of treatment. I then decide what happens when there's a conflict between employment contract and the contract of employment. And typically I would indicate that for certain provisions, such as sort of the actual terms of work, where you can work, your position, all of that, the employee contract will prevail. Then I provide a treatment of what happens between the handbook and the contracts when the handbook would prevail. If they have a confidentiality and an invention agreement, what happens, what's the hierarchy? If they have the specific non-disclosure agreement, some people have that. Some also have like a equity vesting agreement. So you do need to indicate amongst those 3 or 4 sort of documentation that regulates the contract, which prevails, which takes precedence, which will be subordinated to the other. It's important that you have clear language in your employment contract on this issue. Of course, I can't overemphasize record keeping, because, as you know, the Labor Act allows labor officers to literally come in and do on-the-spot inspections. So, of course, they write you before they come. So having your records in order saves a lot of stress. Here I am going to sort of, what is the words? Focus, because I was speaking about this a lot. I'm going to sort of focus on remote work policies. Remote work has come to stay. I know some people have returned to the offices full time, but most offices have some sort of hybrid work. It's very important because remote work comes data risk breaches, confidentiality breaches, also just how do we assess employees who we don't see sometimes most of the time, and performance issues arise. And also the issues of employees who keep two full-time jobs because they are, working remotely. It's important that you have very clear rules in your employment contracts and your handbooks around what would happen, or just even have a separate standalone policy on this issue. Something I didn't mention here, but I think is very important also is social media engagement. What happens? Who can speak on behalf of the organization? What can employees tweet from personal handles? Sometimes employees say personal things. I said this on my handle, and then they go, the world of the internet just goes, oh, where does this person work? How can they have these beliefs? So do you as an organization have rules around what they can do? Of course, while respecting the employees' freedom of expression. It's a very, there are no, I don't even think I have like clear rules on this, because on one hand, we live in time when there is heightened political consciousness. There is unfortunately concerns around religious extremism and what that means for security and also religious freedom. Having conversations just as a firm or as a company around what is acceptable, sort of how to protect yourself, and also the need, particularly for senior management employees, to put out disclaimers and to be somewhat circumspect in what they say. For multinationals, it's a bit more tricky because, of course, in Nigeria, same-sex relationships are prohibited. There's also the cultural nuance around same-sex, just sort of we frowning on same-sex relationships and the whole transgender. I have a word for them, but I suppose some people are going to take offense. I'm just going to keep my word to myself. So the whole transgender sort of conversation. It's important also on these issues that you have clear policies around it that does not, one, infringe on the employees' constitutional rights, also does not infringe on the employees. And it's something I would, to be honest, something I would actually like to see a case law on, where how far would religious freedom and religious exemption protect around persons who identify as same-sex in the workplace in Nigeria, and persons who do not sort of recognize that in Nigeria. It'd be interesting to sort of see what that means. I do know for multinationals, a lot of the diversity training on this particular issue doesn't always respect the cultural nuance in Nigeria, but it's a tension that isn't going to go anywhere anytime soon. So it's one that you need to sit down with your legal team to find what's acceptable within what the law says and what the sort of culture and says. In some, I mean, again, depending on which state of Nigeria you're listening in from, this might not be a concern for you. So I'm not going to go through this. I'm sure you're going to get the slide so you can read it on your own. Here I've just sort of outlined the essential HR documents you should have. So this is, like I said, the idea behind this presentation was also to have you have like a referral, something you can refer to for your work, for the work that you do. So on wages and compliance, and statutory remittances, what I have done is sort of outline very quickly what the compliance areas look like. And here we're looking at sort of, you can't pay less than the minimum wage, payee deductions. There shouldn't be a Personal Income Tax Act. I'm going to update that before you get it. That should be the Nigerian Tax Authority Administration Act, Pension Reform Act, NSITF contributions, group life insurance, leave administration. When can employees go on leave? How much leave can they carry over to the next year? What happens when they are prevented from going on leave by their supervisors? And you have a rule that the leave must be taken within the first 90 days of the next year. What then happens? Salary deductions and overtime obligations, compensation payments. Here I'm speaking about redundancy payments, extra share payments, and also payments on the Lagos State Special Proposal. These are areas that you do need very clear rules around. Paperwork more than anything else, paperwork. In terms of who qualifies for NSITF contributions, ITF contributions, you also do need guidance. You need to make that distinction between contract staff, who are those on the roller coaster revolving door, 9 months, 1 year, and then we renew it, and contract staff that are seconded to you from an external service provider recruitment agencies. Workplace health, safety, and employee welfare. So HSC is evolving. Unfortunately, we don't have a very robust law. For the oil and gas sector, I do know we have quite robust laws for that. But just for the rest of mankind, we don't necessarily have that because our laws are quite old. So the Labour Act has some sort of provisions. The Factories Act has most of the provisions. And then we have just insurance, but we don't really have like robust laws on this. Here have been lots of best practices and contracts, and so paperwork here would also be your lifesaver. And in addition, we're also looking at things that were not an issue before. Mental health has come to stay, and we have. So what's the rule around around that? I do think, and I'm not sure how I missed that, but there's Mental Act. There's a law dealing with mental issues at the moment. What happens with workplace violence? And so for HR practitioners in this area, what you're trying to do is develop what a safe workspace system looks like, and then have proper records around how that system you've developed would work, and what's, constitutes a breach, and what would happen when a breach happens. I do have to say that you have to be very consistent with enforcement. Because if you sit on a particular offense, it happens, there's no warning, there's no compensation, there's no records. You overlook it for the first employee, you overlook it for the second employee, for the third employee. Minor breaches, 2 things it does. Unfortunately, it begins to lower compliance level generally. And then eventually, you then decide to use a sledgehammer with one person. And that person would probably have a good case for discrimination, because they'll be able to say, well, employee A, B, C, D, E, F, G did it. Why is it me that is now the fall guy? So it's very important also to just sort of remember that sometimes things done in good faith could have unintended consequences, and so to plan around that. We need to also have very clear rules around harassment prevention. So your sexual harassment guidelines, what's unacceptable behaviors, but very please have as many trainings as possible. Like I said, some of our cultural practices leave a lot to be desired, particularly for women. But it's a good thing about the workplace is that it's a learning place, and so with time, people overgo this. So I know we say believe the women. I also believe the women. I also say look at patterns. Okay. Pay attention to patterns. And it may well be that sometimes some person is crying wolf. We've had cases where, some women are alleged rape, and there was ultimately no rape. So pay attention to patterns. Believe the women, but pay attention to patterns. That's what I would say to you. And if you don't have a whistleblowing hotline, please have one. Allow for anonymous reporting. I know that we always say we have an open door policy. And that's true. Many times organizations have an open door policies, but the human mind is interesting. And the human person is quite interesting. Sometimes people come genuinely saying, this is what I think should be improved upon. And unfortunately, sometimes what happens is that management doesn't take it very well. So it's important to sort of have this quote and unquote anonymous channels, through which employees can provide feedback without sort of making unintended enemies. So with the Factories Act obligations and the EC accident reports, I'm just going to skip this. These are really for you to remember to maintain these records. I have put this really as a resource guide for you. I'm going to actually touch on the psychosocial and mental health obligations. I think it's very important that we remember that we have a duty of care, which is really a common law duty. And it has two angles, right? Do not do harm, and then when harm has occurred, try and repair the harm. So it's important. While I do know that the workplace is not really a school, or it's not really the employer's obligation to start, so put an unquote, providing all of the social support and psychological support employees need. Given the employees spend a good part of their working lives in the workplace, it's important that employers also sort of step up and do this, because a healthy, functional employee is your best asset, right? So pay attention to burnouts, employees who have gone on leave, who are constantly complaining about tiredness, or have done a 180 character change. They used to be okay, but suddenly are snapping at everybody. Might be that they have too much on their plate, and I want to look at that. Harassment induced distress, Again, this is also potentially litigation waiting to happen because you haven't provided a safe workplace, which is an employer's obligation on the common law, and that common law duty hasn't been raised. What's our health program? And now I'm going to speak to the smaller companies. The bigger companies I know have all of the smaller companies. I'm just going to say be creative, sort of with what you do around this wellness programs. If you can establish a fund, fantastic. If you cannot, look to see which of the HMOs have like wellness packages that you can take advantage of. Do planning sometime for just sort of healthy bonding, probably around one of the many days that have been recognized, either Women's Day or Men's Day or International Workers' Day, where some fun activities could be done as a firm, something that won't break the bank of the firm. I do recognize that for startups and SMEs in particular, and even for one-man businesses where they have a very small team, that additional perks of office cost the most compared to their more institutional organizations. Pay attention to the data you collect. Of course, you cannot, under any circumstances, conduct HIV and AIDS tests or an employee without their consent. It cannot be onboarding, it cannot be pre-employment, it cannot be anything at all. You can't. Otherwise, that's litigation waiting to happen, not HIV and AIDS out. And then for employees who are returning to work, How do you accommodate them? And also, very interestingly, the HIV and AIDS Act has a very interesting obligation here for employers in terms of sort of graduated work, support systems for employees who have HIV and AIDS in the workplace, how to ensure that they continue to do their work, but also work that doesn't tire them out. And Lagos State Special People's Act and even the Sovereignty Act at a national level provides for this also to sort of say if the employee has been injured, can we give them, and sometimes the way, at least in Lagos State Special People's Law, the definition of that disability includes sickness-induced disability, where someone has been ill for quite a long time and is impacted on how much work they're able to do in the workplace. So it's to think about sort of, is there a way we can either reduce their workload, or is there a way we can have a reasonable accommodation so that they're able to do their work and do the work well? There was something I wanted to say here in particular, but I don't remember now, so I'm just going to move forward. And with sexual harassment, of course, have a written policy, have a designated complaint officer, have a non-retaliation obligation. It is very, very annoying, particularly for the men who are dragged to, well, I haven't really seen any sexual harassment. I'm sure it happens from women to men. I haven't seen, in other clients I've heard about any in Nigeria yet. So it's really the men who have this cloud hanging around their head who feel they sexually harassed a woman. And so I can understand the way to deal with this woman that's caused me pain. I think it's important that while we're not doing this non-retaliation obligation, we also as a firm providing support so that it is clear that this person who has been dragged through this process did not do it. If the finders find that they did not sexually harass the woman, the whoever that made the complaint, it's very important that there is also support for the men who are dragged through that process. So the firm, this one don't think that that one, that's like not because they don't catch them, just because they're not catching. I'm sure he did it. We want to also remove that suspicion hanging over their head, so they're able to sort of continue to work well and continue to provide support, service at the best of their ability in the workplace. I'm going to jump now. Now, Femi, how much more time do I have? I know I'm just halfway through my stuff, and even though I'm jumping, how much more time do I have left, Femi?
5 minutes, please.
5 minutes. Okay, great.
Yes.
I'm probably just going to end with this, and we're going to get a slide, so that's fine. I think it's important that we are. We have 5 minutes now. I'm not going to for 1 hour. Anyways, I think it's important that you're ensuring fair hearing in all disciplinary processes, and you have documented processes for your internal investigations, and you adhere to that. One of the things that I also do is provide sort of trainings for in-house counsel regarding how to conduct internal investigations properly, so that you protect the company from harm and also ensure the integrity of the process. Manage all inquiries, and please maintain documentation, and best apply progressive discipline consistently, right? Don't just move unless it's really any egregious misconduct. Don't use a sledgehammer at the best of times. But like I said, be consistent. While I recognize that we all have favorites in the workplace, it is what it is. Do not let that favoritism or that preference for one person over the other lead to the unintentional consequence of creating a pattern or a standard that is less than what the organization ordinarily wants. I thought that this is a good time to actually speak about the PIP process. It cannot be used as a witch hunt process. It cannot be that, life happens, and sometimes your top performer is going through crisis and they move from 100 to 10. Life happens. But it's unusual and quite rare for a top performer to move to underperformance. So it's important that if we, in the course of sort of the appraisals and just sort of appraisal systems, if there is something that is inconsistent, someone has consistently done a 80, 90, and then suddenly we're seeing a 50, 40, something's wrong. I think that the first thing that should come to anybody reviewing that appraisal, that something is wrong. It's not normal. And so you need to sort of interrogate again that appraisal, maybe get someone else to do an appraisal, maybe have a conversation, maybe just even have someone monitor that employee, just so you can tell. Because I think in the one case we have on performance improvement by the court, that was one of the things that the court said, look, this lady in question was a top performer, and then suddenly she's away from top performer to underperformer. It doesn't make any sense. It then did look like some sort of witch hunting was going on, or we're doing one of those, let's phase her out of the system. So you want to also pay attention to that. I'm not going to go through that. You can read it all. I'm going to say a word about redundancies, actually. It's really only for workers that we have clear redundancy provisions. And even at that, it doesn't say how much we should pay. It just says negotiate with them, which is where collective bargaining agreements come into play. The question then also that arises is where we have a company where there employees who are members of a trade union, but not everybody is a member of a trade union. Because as you know, employees can opt out, although the rule right now is that all junior employees, are members of a trade union unless they choose to opt out. What then happens if, we're negotiating redundancies and then the unions have arrived at a higher amount? Employees who are not unionized are not automatically entitled to that higher payout, to be honest. What I tend to recommend, and which is my position, is look, use the CBA as a basis for dealing with all employees. Now, for senior employees, you usually don't have anything. I recommend actually having a documented process for redundancy payments for senior employees. That's my recommendation. Have a documented process for that. If you want to make ex gratia payments, in order to avoid, again, the unintended consequence of creating legitimate expectations, based on the principle of legitimate expectation, it's important that you have some sort of rule around when you would make ex gratia payments and be consistent with those. I think my 5 minutes is up. So I'm just going to stop here. You're going to get the slides and I can take any questions. So probably my 5 minutes is up, so that's fine.
Thank you so much. Thank you so much, Mary. And I apologize.
It's okay, it's fine. This is happening.
Manage the time so we don't overshoot. I know you still have a lot in your arsenal to share with us. I wish we could stretch the time for much longer.
It's fine.
Thank you. Please, attendees, please show your love for Mary. Send her your appreciation. Give her a thumbs up. While we go into the question and answer session, I think the main question we have is everyone is worrying, is asking if slides will be available afterwards. And I think Mary has answered that a couple of times already, that the slides will be available. She doesn't mind the slides be made available to everyone. Mary, hope I'm correct.
Absolutely correct. I don't mind. I mean, we prepared with that in mind, that it's going to be shared with them, so it's fine.
All right. Thank you. So we have a question here from Wumi. She says, please clarify the position of contracts, like contract staff, temporary staff, as opposed to permanent staff and statutory deductions. Also clarify the rounding up time for benefits in favor of an exiting employee.
Okay, so the rule of thumb is that your contract staff is an employee. But the laws that provide for those benefits do not distinguish between contract staff and permanent staff. It just says employee. So your contract staff, so which is why I distinguish between contract staff who are on the revolving door, where every 9 months, or every 1 year, or every 2 years, the contract is renewed, vis-a-vis the contract staff that are seconded from the recruitment agencies. Contract staff on the revolving door are treated in terms of statutory obligations, pension, health, group life insurance, counting the number of employees for purposes of remittances to NSITF and ITF. Contract staff and permanent staff are treated the same. What if we're dealing with contract staff seconded from recruitment agencies? They are not your employees. So you, the company, does not owe them anything. Their obligations come from the employer of record, which is the recruitment, and so they're the ones going to pay pension, they're the ones going to pay health, they're the ones going to pay group life insurance, all of that. They are the ones. And even for purpose of compensation packages, redundancy payments, one of the conversations I know happening now with contract staff, seconded contract staff, is that they are, at the time we're negotiating, you're also thinking about, look, if there's going to be redundancy, what's going to happen and how we're going to deal with that. But contract staff that is on a fixed term contract, that when it's terminated, we either ask them to continue. Many times they ask to continue, or we ask them to go. Those are entitled to pension, group life insurance, health insurance. Now, but if it's seconded staff, they're not entitled to that. Now, in terms of the rounding up, I would just say rule of thumb, you have to, if employee, now, two things. If the employee is being asked to resign, or the company is the one terminates, and please don't ask any employee to resign, that's constructive dismissal waiting to happen. Even though I know it continues to happen, but please don't ask them to do so. If you're terminating an employee, now, depending on whether the termination is for course or just for convenience, and so you have a gratuity or some sort of benefits employees, or even in terms of vesting, for instance, where I'm supposed to get this benefit after I spent 3 years. I'm at 2 years and 9 months, or 2 years and 8 months, or even 2 years and 7 months. And then the company, at their own instances, terminated the employee, and it's not for cause. So it's not because I did something, I was misconduct, or I lost the license to practice, or the courts are likely to just based on that arithmetical provision, again, because 2.7 ordinarily is rounded to the next number. So anything over 2.5, arithmetical, what do you call it now? We know that 0 to 4 is treated as 4 points. So if it's 5 years and I just spent 4 years and 1 month, that's not 5 years. 4 years and 5 months is not even 4.5. But anything from 4.5. So just to use the same arithmetical propositions, we know that 0.5, we're rounding up, we'll round up to the next. We're going to round up to the next number, 0.5, to be 0.1. 0.4, we're rounding down, so it will be 0. So it's that sort of a principle that the court used. It was just the arithmetical principle. We know where you round off. We're trying to round off the next number is 0.5. But I also think that the courts, just based on the case we've looked at, would also look at, who left and why, the reason for who caused the termination, and what is the reason for the termination.
Thank you for that. And we have another question from Ayotunde. Question about what labor laws are applicable to gig jobs and app-based jobs like Bolt, Fiverr, Upwork, etc.
So the challenge is that, first of all, they are not treated as employees. The jury is out. I disagree. I don't think that they're exactly employees.
I also don't think that they're exactly independent contractors. I think they are a very unique sort of hybrid type of work, and we need laws around that. That's what I think is best serves them. And also just sort of looking at what other jurisdictions are doing, China, Canada, that sort of UK, that's sort of what serves them best, right? Now, under Nigerian law, they are treated as not employees. So far, the cases I've seen, they're not employees. I disagree with that, and I've told you why, but so far they're not. So it's just based on what your contract says. So because they're not employees, and I think that if we're using the control test, there's an argument to treat them as employees, but if we're using the mixed text principle, there is argument to treat them as independent contractors. So it depends on what your contract says, to be honest, unfortunately. So because you're not even treated as employees, the contract will determine sort of, so you won't have fixed work hours. They won't be able to determine what time you work. Of course, the algorithm will have a say as to where you do work because they bring you work around where you actually are, which is a problem because then you don't really have control over place of work. It's sort of shared. Your wages are it's not even wages, it's fees, right? Your fees are entirely dependent on what the platform owner says. So I think the first thing is to recognize them as employees. If you're a platform worker, strictly speaking, you're a freelancer, the default is to treat you as an independent contractor. Although when we do begin to interrogate the principles of independent contractor, we see that some of them don't quite fit. But again, even from an employee perspective, you're not quite there. So if are gig workers here, what I would say is, again, I'm going to tell you again, get your PVC and votes. But start to lobby senators and House of Rep members who will pass a law to protect your interests. But you need a PVC to get them to. So get your PVC organized and then go have a conversation. So you can have a law. I certainly think that you do need a law that sort of deals with your unique where you sit. You're not entirely employees, but also not strictly speaking independent contractors. But as of today, under Nigerian law today, you're treated as an independent contractor.
All right, thank you. We have two more questions. One says, please, what is the difference between garden leave and terminal leave? If you could take this in 30 seconds, so we can ask.
I don't do things in 10 seconds. Femi, please don't let me deceive you. I don't understand 10 seconds. So garden leave.
30 seconds.
Femi, I don't answer questions in seconds, please. Let me answer the question.
Go ahead.
Garden leave. Garden leave is, we have agreed that a senior employee needs to leave. We want the senior employee to serve out the notice period, which is anything between 3 to 6 months. Now, because at the point when you are saying somebody should leave, relations are broken. But we want them on our payroll for that 6 months. And so what garden leave does, and the way it is drafted, is we say, we can ask you not to come into work. We can vary the type of work you do, which means we can reduce your work. We can give you other types of work. Of course, we cannot suddenly ask an executive to become a driver. We can't do that. But typically what happens is that the amount of work you get is significantly reduced. The people who would usually report to you might be removed. You would sometimes say, oh, don't come into work for like a month. But you're going to get all your money. You're going to get your salary paid. You're going to get your benefits paid. Just don't want you to work. So what they're trying to do is to manage. They want you on the payroll, but they also, I don't know, for whatever reasons, they want you on the payroll. But during that time, they want to manage how much access to information you have, and also have you sort of provide all of the information they need for a seamless handover. So whenever you leave at the end of the terminal process, they don't need to come back to you. Now, terminal leave, and I don't know what they mean by terminal leave. Terminal leave, my understanding is that you have some leave left. You're entitled to 50 days, you're entitled to 25 days of leave. You've taken 15 from you had 15 left from last year. This year, you have maybe another, I don't know, 10, 20. at the time when we don't want to pay you that leave allowance. We want you to please use it within your notice period. Okay. What that then means is that instead your notice period is now your leave period. We ask you to go on leave in that time. That's what I understand terminal leave to mean. So it's slightly different. One is that it's unutilized leave we want you to use during your notice period, so we don't pay out leave to you. And the other one is once you're on the payroll, we want to vary sort of how much access to information you have. So even when you're on garden leave, if you have unutilized leave, they ask you to utilize everything. So sometimes it's overlaps, but one is actually a tool to manage the exit for a senior employee so that it minimizes the amount of damage done both ways. And the other is a Naira and Kobo conversation. He's going to be going on leave, I'm not paying you this money. I hope that answers the question.
Yes, it does. Yes, it does. I hope the asker is also satisfied with it. Nathalia's hand is raised. Is that a question? Do you have a question?
Yes, I do. I have a question.
You have a question. Okay. Before you ask your question, the vote of thanks will be taken by Nathalia. So I would like that after your question, after Mary answers your question, you go ahead and give the vote of thanks.
So that's the last question in the chat box, Femi.
Oh, there's another question. Okay, there's one more question in the chat box, just came in. Does the staff who has instituted a matter in court still have a right to continue on the job?
Well, they are still an employee now. You sacked them. And I know it's actually, you know, we are in court with me once we come into work. I suppose is where garden leave is useful, right? You can ask them to be in the house while you are, you know, but it's crazy, but you haven't sacked them. And I'm not, I suppose if I was a judge and someone was suing you for something, you sacked the employee, I would be very upset and I will penalize you, actually, my judgment. So sometimes you have a maintain the status quo. It's actually a difficult place to be in, to be honest, very difficult. What I would say is that if that happens from a very strategic point of view, just to protect the company and also to make the employees' experience not so terrible, reevaluate their work. How much work they can do, how much access they have to third parties and even other employees, which is why also very useful sort of when you're describing the work, the clause that describes the duties of employees. Usually there's that sort of omnibus clause and such other duties that the company may require. Sometimes you see language that says, and the company may ask some other person to do the work that you're doing. It's just ways of managing that risk. But they're still employees. So until you sack them, they have to come to work. You have to pay them. You have a duty to provide work to them. So, I mean, this is an interesting thing and something I think that actually you should have a clause dealing with this, either in your employment contract, but probably, I think, most appropriately in the employee handbook, so that it allows you to take certain decisions to protect the business and manage that very strange relationship, to be honest. So the clause saying something around if there's a court where we will not terminate your contract during that time, you would reserve the right to sort of vary their duties, or second them somewhere so you're not seeing your offers, or sort of treat them somewhere, or ask them to work at home for a while, or require them to not come to work at all while their salaries are being paid. Yeah. It's a difficult place to be honest. It is what it is.
Right. Thank you. Thank you for that, Mary. Nathalia?
Yes. Can you hear me?
Yes, we can hear you.
Okay, thank you very much. Mary, that was very fantastic. But before I go on, let me ask my question. Now, I know an employer has to give a contract of employment to the employee within 3 months, right? And I know the law says it could be written or oral. So what happens if the employer says, you know what, there's no need, I don't have time for all of this. Let me just, we just have an agreement. I'm going to pay you this amount. These are rules and regulations and all of that. I know that the importance of having a contract of employment is that it clearly states out everything, and so there's no ambiguity. But where this employer says, I'm not ready to give you all of this, maybe try to escape any form of responsibility, what should the employee do? Would law still recognize the oral agreement between both parties? That's my question. Thank you.
So strictly speaking, if we're looking at what the Labour Act is, so particularly for workers, you actually, I think that the Labour Act tried to do away with the risk arising from oral contracts by requiring a written document within 3 months. Now, the law also recognizes that sometimes, people circumvent things. So the law can infer from the facts of the case that there is actually an employment contract. And if the law is not able to infer all of the benefits, the courts, I believe, will defer to Labour Act and say, well, you do not provide for annual leave, when this is the amount of annual leave they're entitled to, based on the Labour Act. You didn't give them maternity leave. The Labour Act says you should give them, this is what they're entitled to. So if there was a dispute, the court would, based on the facts, can infer an employment contract. And for the benefits that are statutory, the courts would actually infer that. Now, where I sort of am not quite sure where the courts have come out very strongly on is on pension contributions. I personally speaking, I think that if we infer that as an employment contract, so long as the employer in question has up to 3 employees, then that obligation to pay at the very minimum what the law says, which is 10% of the employee's salary, which of course we can tell what the employee's salary is because a certain amount of money leaves every month to the employee's contract and it's consistent. It's usually the same amount of money, unless there's a salary increase and then you see the variations. I think that I certainly think that the courts should also infer, but if the courts infer that there's an employment contract, in the judgment they give to an employee, if I were the employee, I would get a lawyer to write the company to demand my pension contributions. The don't, I would put them to PENCOM because there is already a formal court document that has supported my claim that there is a contract, even though it's oral. So oral contracts don't do a disservice to employees, but yes, it could well be that there was an oral contract. The challenge then is what exactly is the benefits, which is then a fact-finding mission. And many times it's not really into the best interest of the employee.
Thank you very much. So it's been an interesting day. Honestly, my note is full and I don't know. I know you don't have enough time to say everything. I know it's loaded.
Okay.
And I know you have a lot to say.
Slide, so that's fine.
Yeah, I know. But it was quite interesting, really. And I want to thank Elan for organizing this webinar, among the series, because the truth is that when we do this, we help the public, not just us lawyers, to learn, so everybody should comply with what's going on within the labor, space. So, and it's actually very important because most of these disputes we see today are coming from the HR, the drafting of contracts and all of that. If it's taken care of at the very beginning, then we'll have less conflict or dispute arising from employer-employee relationship. So I want to say thank you so much to Elan for organizing this webinar. And Mary, thank you for an excellent delivery of this session. Anyway, I didn't expect anything less from you. And being my boss, my oga, well done. Thank you so much. I want to thank Femi, excellent moderation as well.
Excellent.
When you mentioned Arsenal, I thought it was Arsenal. I'm an Arsenal fan. I'm so excited, thinking you're going to talk about us here today. But we are talking
Arsenal,
about
22 years after we won. They should just be giving us a
So we are grateful and we're thankful. Thank you, Femi. It was an excellent moderation. And thank you for keeping to time as well, because time is of essence and you're able to help us organize and put it at the right place. So I want to thank everyone who joined this webinar. Thank you for coming. Thank you for staying to the end. It's quite interesting. And thank you for all the questions that you asked. It also helps to elaborate our knowledge. And I took down a few things. If you leave here today and you didn't get anything for what was discussed, please bear in mind that HR, the role of HR is no longer administrative, like Mary rightly pointed out. It's gone beyond that. I love how she said it at the end. It's now a strategic, legal, compliance, and risk management function. And so for you to be able to function in all this role, you must be conversant with the relevant laws. Know the laws, know when the law changes, know when things happen. And I think many mentioned the Employee Compensation Act. Some, part of the law was amended or something. You need to be very conversant as HR and be able to advise management as well. Bear in mind also that you have to understand that the employee rights, and it's actually governed by the Constitution. And then we have the data protection. The Nigerian law is very big on this now. You must be careful in collecting data, how you use it, how you process it. It's important that you know all of this. And then the contract of employment. It's not a big deal. Someone comes to work for you, have it there clearly spelled out, and the person understands what they are doing. And at every point in time, they can make reference to it and know what their rules and regulations are. And then constant training. So as HR, it's important that you take note of all of this. And then mental health. Nigeria is a very wonderful country. People are frustrated. A lot of things are going on. So as HR practitioners, you have to be very humane in drafting your policies, your handbook, everything in compliance with the law. And just besides the law, remember international best practices. It's not just about the laws anymore. How is it repugnant? Is it in compliance with best practices? So it's important as HR practitioners that will bear all of this in mind. So Mary, thank you so much for a good job well done. And we'll look forward to another webinar organized by Ellen. Thank you everyone for coming. Please do enjoy the rest of your day. I saw a question on
Nat, before you go, I think it's important to speak about how to join Ellen.
Yes, I saw a question there. Someone asked the question, how would it join Ellen? Please drop your email, we'll get it and then send that across to you, information on that, on how to join Ellen. Meanwhile, you can go to our website. When you get there, you see how to apply. Once you do that, we'll receive your application, we'll schedule you for an interview, and then we'll take you from there. Thank you very much. Max, I see you all the way from Abuja. Thank you, everyone. Please enjoy the rest of your evening, and bye.
Thank you, everyone. Bye.
Bye.